Good morning. My name is Robert Nichols. I'm with the law firm Nichols Lew. With me is my partner, Carla Weiss. As you know, last week our firm filed a bid protest on behalf of BroadReach, challenging USAID's selection of a cooperative agreement rather than a procurement contract for a particular foreign aid project in South Africa. PubK distributed this complaint to the broader USAID community because it has potentially significant impacts beyond this protest as well. Our friend Bob Strauss immediately sent me an email saying, "You may have shot yourself in the foot with this litigation, given that 62% of the newsletter subscribers are nonprofit organizations." I actually respectfully disagree. I think that the system works best when it's a level playing field and everybody's following the rules and everybody knows the rules. And I think that this is an important issue for this entire community and that it should be focused on this issue. So we put together this webinar today to discuss the implications of the BroadReach protest, where we're coming from on it, what the rules are, and what we think that this means. I mentioned that we're partners at the law firm Nichols Lew. Our law firm focuses exclusively on serving both contractors and not-for-profits that receive federal funding through U.S. grants and cooperative agreements and contracts. We left Big Law to start this firm in part because we represent a lot of development organizations, and the big firm model didn't really fit very well for that. So at our firm, we're actually able to charge full rates to defense contractors and give discounts to the international development community and work with kind of who we'd like to. I think a little context is in order here because I think there's a possible perception that this is favoring contracts over not-for-profits. And I think you'll see as we discuss this today, that's not how we see it. Over my career, about half of my clients have been USAID organizations, and about half of those are not-for-profits. In fact, my three largest client engagement matters over the past 15 years have been for not-for-profits. In 2010 and 11, I represented the Academy for Educational Development after it had been suspended for improper activities. We tried to get them cleared of the problems to continue work, but when that failed, we developed a plan to move the programs and the people over to FHI 360 to keep them going. In 2016-18, I represented a large international medical NGO accused of allowing its subgrantee to commit fraud against USAID in the Syrian relief efforts. And in 2019-20, we advised Mercy Corps in dealing with their compliance issues related to the sexual abuse allegations. So I tell you this to give you context of where we're coming from. And in addition to being a partner here, I'm also general counsel for a not-for-profit organization called CRDF Global that works mainly for the State Department and NIH. So that gives you a little bit of context. We did not bring this protest to be biased in favor of one or the other. As I mentioned, we're bringing this because we think that there's a real problem with the system here. And we think that this problem actually has rather negative implications for the whole community. So there are three reasons we decided to take this on. First, these bid protest challenges of choice of instruments determinations, they've actually existed for over 40 years. It's just that USAID hasn't really encountered them before, but they've been rife for other agencies. Second, and we want to help bring that overlay to USAID to help USAID get this right. Second, and maybe a bigger driver is, in our view, good government means predictable and reliable government, getting value for money and a level playing field where everybody knows the rules and everybody can play by them. USAID holds its implementers and implementing partners responsible for compliance, but they're actually ignoring the law in this area. And the result is less predictability that leads to bad results. As a quick sidebar, I woke up this morning and I got dressed for late October weather to take my dog for a walk. I hadn't checked the weather, and so I put on this big fuzzy sweater, and I was very hot for the whole walk because for some reason it's October 31st and it's 80 degrees out today. And then it hit me. Unpredictable weather. How am I going to dress for? It's the same thing for USAID implementers. You guys need to develop your technical capabilities, your business development plans, and your compliance systems around the type of funding and work that you get from USAID. And when USAID is unpredictable and arbitrary about which instrument they're going to choose, what it means is you can build your entire systems around certain programs, and aid decides to use a contract versus a cooperative agreement, and you can't even bid on it. We actually think that's wrong. We also think that USAID budgets are under a lot of scrutiny for not providing value for money and for inefficiency. And we think that this choice of instrument situation actually contributes to that. And there's a solution to that. And the solution is to follow the law. Congress passed a law, and we're going to talk about that, to specifically tell agencies how to choose between assistance agreements and contracts, specifically to create predictability and to create a level playing field for competition. The third reason we took this on is we didn't want to shy away from this bid protest at the risk of scaring not-for-profits, because as a matter of fact, whether you're a not-for-profit or a for-profit, you can do contracts and you can do assistance agreements. In fact, for-profits and not-for-profits can do both. I think that there's a perception that they can't, but it's actually pretty simple. Whatever you're going to bid on, you just need to have the right compliance systems in place to be able to bid on it. The way I think of it is, before you play Monopoly, you read the rules on Monopoly and you comply with the rules, and then you get to play Monopoly. And so we work with a number of organizations that have said, we want to have both. So we need compliance systems for both, and they're frankly not that different. Set us up for that, either two separate entities, one for profit, one not for profit, or within the same organization. And then you can bid on anything you want. You're not actually excluded from anything. And so we actually think that that is the best approach for strong, healthy organizations. Additionally, the more you can win, the lower your indirect rates get, and the more competitive you are. And I know that some not-for-profits think that profit making is kind of dirty business when you're doing humanitarian work. I would actually argue, if you don't want to make profits, don't distribute your profits to your people, but put them into your reserves and invest them into your humanitarian purposes. Take advantage of the fact that a contract includes some profits, or bid it with zero profit. But the idea of going for contracts, in my opinion, should not be that's dirty work. It should be, this is more opportunity to pursue our humanitarian mission under a different type of vehicle. And if we set it up right, then there are a lot of rewards for that. So why do not-for-profits avoid contracts? Well, to be very blunt, which I tend to be, I think, in my experience, the answers are fear and complacency. Many not-for-profits don't have the compliance systems set up yet. That's actually really easily solved. It's a checklist. You figure out the checklist of what you need to do, and you put it in place, and you comply. By the way, the organizations, in my experience, that have gotten into the most trouble are not contractors that have more complex compliance obligations. It's the not-for-profits that don't put in compliance systems at all. And so this is a matter, this is an administrative technical matter to make sure that you have the right systems to be able to do the work. And a lot of organizations have just avoided that. I think a lot of not-for-profits also think that their indirect rates are higher, which makes them non-competitive. That's actually a simple answer too. I think a lot of not-for-profits put costs into overhead that could be direct charged, and maybe there's some cost controls that go into place. And so this idea of opening up these legal instruments to everybody, I think, is the right idea. So why does USAID choose legal instruments unpredictably and arbitrarily when providing funding to this community? Well, I think there are also 3 reasons for that. And these are not reasons that are just in my head. I actually published a white paper on this about 8 years ago, and I got calls from USAID lawyers and contracting officials saying, we know we're not complying with the law. Somebody needs to sue us to make us comply with the law. And we now have somebody. For years, I've been advising clients, don't be the first one to stick your head up out of the foxhole on this. Let somebody else do it. Well, we now have a client who said, we need to do this, and we're proceeding, and so we've taken this on. So 3 reasons why agencies do this. Number 1, I think some bureaus and programs have a history of using a particular type of instrument, and they just don't want to change it. They're used to what they're used to. Second, I think USAID has a hard time getting contracts awarded and money out the door, and it's due to their slow and inefficient procurement processes and mistakes that they make. As you know, it can take years for USAID to formulate a good competitive RFP with a clear scope of work and evaluation criteria. And then, if an interested party believes that the agency made mistakes in the procurement that put it at a competitive disadvantage, they have the right to protest. And when agencies do commit errors, the protest fora tell them to go back and fix it. Or sometimes they do it voluntarily. USAID has a track record where bid protests end up with corrective action about 62% of the time. So over half of protests that get filed end up with the agency having to redo the procurement. What does that tell me? What that tells me is USAID needs to fix its procurement system, not try to sidestep the procurement system by improperly using grants and contract agreements. The third reason I think aid prefers grants and contract agreements is I think that they misunderstand the law in this area. And this is what we're going to get into some more. So this is why we accepted this engagement, to try to clean up this area of the law for the good of the community. And as you'll hear later, this may be the first major test of USAID's choice of instrument decisions, but other agencies have been dealing with this for over 40 years. And one in particular, HUD, is a very special use case that we'll talk about a bit later. So as you know from the brief, the governing law is called the Federal Grants and Contract Agreements Act. And this is why Congress passed this law in 1977. Before that, they made a finding that there was no uniform statutory guidelines to tell agencies how to select between grants, cooperative agreements, and procurement contracts. And this failure to distinguish between the types of instruments and the inappropriate use of grants to avoid the procurement system had led to red tape and administrative requirements in grants. So they passed this law, and they did it for a number of reasons: to prescribe criteria for agencies to use in selecting the appropriate instrument for any given transaction, to promote increased discipline for agencies in how they select among them, and to also maximize and encourage competition. The statute itself has a couple of key provisions that I'll focus on here. Section 6303 deals with contracts, and it says an agency shall use a procurement contract when the principal purpose is to acquire property or services to directly benefit or for the use of the United States government. In other words, if the government is spending money to help the government do its own job, it's supposed to be a procurement contract. In contrast, grants and cooperative agreements shall be used when the principal purpose is to transfer a thing of value, money or otherwise, to a recipient to carry out its own purposes. And so the real issue is the primary purpose of the transaction to help the government do its job, or is it to help the intended beneficiary do its job? This was a little bit confusing, so Congress went back and clarified this in 1982 and said this choice of instrument when you're giving money to an intermediary third party, this intermediary relationship is based on this principal purpose. And again, whether you're acquiring or to services to assist the government or giving money to an intended beneficiary to help them do it, that's really the defining issue. So why has this been so confused? Well, I think it's actually been a desire for it to be confusing. I think that the agencies did not want to be told what to do in this area, which is exactly why Congress passed the law. And what happened was after the law was passed in 1978, OMB put out guidance saying, here's what the law means. And it recites the principal purpose test, but then it goes on to say that the determinations of the principal purpose can involve agency policy decisions and allow agency flexibility to select the instrument that best suits each transaction. Well, the statute doesn't say that. And so why did they say that? They were trying to read that into this statute. And if you look at the legislative history of the statute, there is discussion around whether there should be policy decisions and flexibility, but that didn't make it into the statute. What's in the statute is clear test on the primary purpose, and it does not say anything about agency policy decisions or flexibility coming into that decision. OMB the next year said, GAO the next year said, OMB, you got this wrong. The statute says primary purpose test. It does not say flexibility. And we want you to go back and change your guidance. And for over 40 years now, OMB has just flat out refused to change their guidance, creating this ambiguity. The GAO Red Book makes clear to agencies exactly what the rule is. This primary purpose test says nothing about flexibility or agency policies coming into place. So GAO, I think, has been clear about the intent of this. And I think the face of the statute is fairly clear, but it has created ambiguity. And that ambiguity has led to agency decisions that have then been protested, and time again, GAO or the Court of Federal Claims have usually said, apply the primary purpose test. Sometimes, and Carla will talk about this, they've actually relied on the OMB guidance to say, but you have flexibility. And we, again, think that that's wrong as a matter of law. So I'd like Carla to talk about the protest decisions in this area.
Great, thanks so much, Robert. So, I am primarily a bid protest lawyer. It's what I do here. And so when you start talking about how do you actually deal with these choice of instrument questions, the answer has largely been through the bid protest process. And so what that means is that any interested party, so an entity, whether it's a contractor or a not-for-profit who is concerned about a choice of instrument decision being made, has the ability to challenge that decision. They can do it either at GAO, the Government Accountability Office, or at the Court of Federal Claims. They can also go to the GAO and then to the court. And the decisions at the court that they disagree with can be appealed to the federal circuit. And so all of this means that there are oversight bodies who will consider these questions. And I think it's important to note that these entities have jurisdiction over the procurement process. They don't have jurisdiction over grants or cooperative agreements in so much as, was the decision right? Was the award decision correct? So what this really comes down to is, what should the initial decision have been on the choice of instrument, contract or assistance agreement? And so over time, there have been dozens of agencies that have been protested on these issues, many at GAO, and then a number of fairly prominent recent decisions that have made their way through the courts up to the federal circuit. And as we'll talk about, there's been some less than clarity in answering these questions. This one, okay. So the first one we're going to discuss is CMS Contract Management Services v. US. So this started out first at the GAO, then the Court of Federal Claims, and then onto the federal circuit. So what you have here is HUD has Section 8 housing by which they try to help low-income Americans get housing services. That can be either in public housing or in private housing, through which there is payments made to help with rental assistance. And so it is with this unit of these privately owned dwellings that these cases emerge. So HUD has only a limited number of staff, and there's private dwellings all across the United States who need to be dealt with through the government, through their funding of Section 8 housing. And so they have largely outsourced this contract administration services, both to be more close tied into the communities where these services are being performed, as well as to give relief to HUD staff who otherwise would have to balloon in size just to deal with Section 8 housing. So HUD, there was a long history of how these services should be procured. What happened here is that they decided these should be cooperative agreements, that the agency decided that we're going to do this not through procurement contracts, but through assistance agreements. And cooperative agreements meaning the government is still going to have a fair amount of involvement in the process. So there's a series of protests that emerge. There's a fair amount of backstory, but the agency kept making changes, and ultimately you get this series of cases. So I will say I read a lot of protest decisions, and the CMS case coming out of the federal circuit is very elegant. It's clear, it's easy in discussing how agencies should be making choice of instrument decisions. And here the court found that HUD got it wrong. This should have been a procurement contract. And the reason was that the primary purpose was to procure the services of a third party to help HUD do its job. So if a third party wasn't doing this support services for these private dwellings, HUD would be doing that. And so it is assistance to HUD staff so that they can focus on other aspects of their job. So they go through the decision about, well, HUD argued, no, we're transferring a thing of value for the benefit of these third parties. And the court disagreed, and for two reasons. One, that ultimately they were really a pass-through for these funds. They went from HUD to the third party to the Section 8 beneficiaries, or directly to the dwellings. And so there was no ability for the entities themselves. They weren't keeping that money. They weren't deciding how to use that money. It was really a pass-through. There was also an administrative fee, but that was deemed to be effectively, the operating expenses. So the idea of, when you look at the 6304 and 5 sections on grants and cooperative agreements, that you're transferring a thing of value for the benefit of the entity, they decided that wasn't the case here. And so ultimately what they said was that HUD created an intermediary relationship. So you'll recall Robert said, if it's an intermediary relationship where the primary purpose is to benefit the federal agency, that should be a procurement agreement. You're still looking to a procurement contract. The proper instrument is procurement contract. And so they say they're merely used to provide a service to another entity for which is eligible for assistance. So I think after the CMS decision, folks thought they understood the rules. They thought everyone understood, hey, principal purpose test is how agencies need to be making these decisions.
With one caveat, and that is if the enabling legislation for the agency or the program legislation says to use a granted cooperative agreement, of course you do that.
Sure.
And we're going to come back to that a little bit later.
Yep. So when we get to the Hymas case next, that becomes a large part of this decision is that question about the enabling legislation. So CMS is 2014. 2 years later, we get another series of cases that make its way up to the federal circuit. It was a real barn burner couple of years for the federal circuit and choice of instrument cases. If you're into this, it was pretty exciting. So here you had the Department of Interior Fish and Wildlife Service. They have what they call cooperative farming agreements by which they would work with individual farmers to grow crops on public lands to help with conservation for migratory birds and other wildlife. Great thing. We like birds and wildlife. And so they're doing this again through these cooperative farming agreements, what they call CFAs. There's another set of protests involving should this be a cooperative agreement or should this be a procurement contract? So here, Farmer Hymas, it's not often in government contracts you get to say, or in this area, you get to talk about a farmer, but he was not awarded one of these CFAs and he protested saying this should have been a procurement contract. So the Court of Federal Claims, applying what they thought was clear guidance from the CMS decision, agrees with him and says, yes, this is a procurement contract. This is coming in it's benefiting the agency to meet their mission, and they're doing it through an intermediary. Somewhat, I think, surprisingly, the Federal Circuit disagreed. And the decision, I mentioned the CMS decision is elegant, easy. The Hymas decision is not. The Hymas decision goes through a lot of issues in ways that are, I think, somewhat less clear and provide less clarity to agencies in how to think about these choice of instrument issues. So the Federal Circuit majority, it was a split decision, a 2-1 decision. They said, first, to Robert's point, the relevant laws here authorized cooperative agreements with any persons. There's a significant amount of discussion about what the actual legislation says and whether or not the farmers counted as persons for purposes of this enabling legislation, or if it needed to be private organizations or entities. Ultimately, they agree or determine that there is some ambiguity in the statute, and the agency, under what was then Chevron deference, is determined that the individual farmers could count for cooperative agreements under this legislation. So that's kind of the first aspect of this decision that really gets into what do we look at for an enabling legislation. The second question is then they turn to the primary purpose test. And here, I think, is both some substantive, kind of the substantive question of what are the specific facts for this? Because that's always what the court is going to look at, is the specific facts of what is being procured. But then there was a kind of higher level question as we got to about flexibility and who gets to make these decisions and how much flexibility is afforded to them. So what the majority said here is the relevant or the primary purpose of the transaction was to transfer a thing of value to carry out the public purpose authorized by law, and the intended beneficiary was the farmer here. And so they said to conserve wildlife on the refuge was the public purpose. And so rather than it being where, unlike the prior decision where they just said, you have effectively an intermediary pass through, the court here said, no, the beneficiary of this is the farmers or whoever has the CFA. And so that's the first way that this is distinguished from the prior case, is them considering what is the primary purpose and applying, again, the law to these particular facts.
And this court cited the OMB guidance saying flexibility,
Yep.
right?
Yep. So where they got there, so that gets into kind of this broader question, but they absolutely cite, unlike CMS, which didn't cite the OMB guidance, they rely here on some of this legislative history that Robert cites, that again was never actually incorporated into the act, as well as OMB's guidance. And so what they're looking at here is a different paradigm, I think, than the CMS decision 2 years later. And so it creates a fair amount of confusion. The dissent much more closely aligns with CMS, saying, the principal purpose is for the government to acquire farming services. So much like if HUD was not getting a third party to administer the Section 8 housing and work with the private entities, here, if the farmers were not planting crops that are being eaten by nice migratory birds, that the Fish and Wildlife Service would have to do that. And so they would be the ones performing this work, but for the fact that they have outsourced it to the farmers. And they take strong disagreement with the majority's opinion that there is flexibility. So the dissent goes through and says that it doesn't have flexibility, and they focus a lot on the term shall. So if you recall, back when Robert went through the actual act, it says that an agency shall use a procurement contract in certain areas, that they shall use a cooperative agreement or grant in others. And so their real focus in this ended up being that there is no flexibility. Once there is the principal purpose, that's the determining factor. And I'll note, even if there's not flexibility, that doesn't mean you end up in a procurement contract if the primary purpose would still fall under an assistance agreement. So I think there's two areas here where the majority and the dissent disagree on the principal purpose or the primary purpose, but they also disagree on the broader context of what is required for agencies and their degree of flexibility. So this is now 8 years ago. And I think coming out of this decision, there was not sunlight towards it. It was kind of more confusion and obfuscation. And I think part of that is now why we're here in how do we address that confusion and try to get that clarified so that we're not having these continued issues.
Yeah. So as confusing as this may be for agencies in making these decisions, the courts and GAO, who are supposed to be the decision makers here, made it even more confusing. In CMS, HUD chose cooperative agreements. It went to the first went to GAO, and GAO said, no, it should be a contract.
Yep.
Then went to the Court of Federal Claims that said, no, it should be a cooperative agreement. Then went to the Federal Circuit that said, no, it should be a contract. In HIMIS, the agency chose a cooperative agreement. It goes to the Court of Federal Claims that said, no, it should be a contract. Goes to the Federal Circuit, no, it should be a cooperative agreement. And so part of this, as Carla mentioned, is a proper application of the principal purpose test. But part of it is, do agencies get actually flexibility to do what they want and put their own policy overlays in place? And that's a big part of why we have brought this. You can't have consistency and reliability in the government selection of instruments when the law itself is unclear. And that means, again, contractors and not-for-profits can't really plan their technical capabilities and their administrative functions without really knowing what the government's going to do. So BroadReach is the first major protest involving USAID. As we mentioned, there have been many others. We think that it could very well end up in a decision that says the law doesn't actually give agencies flexibility. So OMB, your guidance is invalid. USAID, your ADS 304 guidance that recites the principal purpose test, but then in the very next sentence says agency has flexibility, that's improper. And so we also think that this is going to lead to more organizations who are shut out of a particular program based on the agency's selection of instrument, saying, we think you got that wrong. So the key questions under the analysis, we won't go through these here too much, but what a court should look at, we believe, are the program legislation, who the recipient is, and why the money is being spent to assist the intended beneficiary or to assist the agency itself. Invalid considerations, and this is very clear, there's no dispute over this, is agencies are not supposed to choose cooperative agreements and grants to avoid competition or to avoid the bid protest process. We all know that's exactly what they're doing, but that is not what they're supposed to be doing. But there are a couple of pitfalls in this protest. Sometimes you have to take the case you got and do your best with it. Well, here the government is making an argument. If you're going to challenge the choice of instrument, you were required, BroadReach, to do that before you put in your initial concept note. And because you didn't, you waived the ability to raise this issue, and it's untimely. We are going to fight that, and we are fighting it, and we're essentially saying, listen, the bidding process hadn't closed. We still have a chance to do this. But this particular protest may end up falling on that issue. Other protesters who want to challenge this need to get out of the gates early and challenge these things before any initial submissions are due. There's also a risk that the court will actually look beyond the statute to the regulatory history and cherry pick parts of the legislative history to say, well, in fact, agencies do have flexibility. And if that happens, forget about predictability, because agencies are going to continue to do what they want. So right now, that is actually the law under the Hymas case. We think it shouldn't be the law, but there's a chance that the courts end up affirming that for one reason or another. So maybe this fixes this issue, maybe it doesn't. We'd like to actually now turn to a colleague, Orlando Cabrera, who's a partner over at Arnold, Gordon, and Gregory. The reason we bring in Orlando is not a government contracts lawyer. He is a government relations lawyer. And Orlando has been involved in the HUD situation after CMS. And so over the past 10 years, HUD has sought to still get around the idea of going to procurement contracts. And the way they've done it has been kind of interesting. What HUD has done is said, well, we still want to use cooperative agreements. And the reason they're doing that, by the way, is not because they actually believe these belong as cooperative agreements. They cannot get a procurement done to save their lives. Every time they put out an RFP, it gets protested. Every time they award a contract, it gets protested. And they absolutely want to avoid the protest process. So what are they doing? They're going to Congress and asking them to change their law. They're asking them to write into the Section 8 law that this agency shall use cooperative agreements as the choice of instrument for these Section 8 contracts. They're trying to do an end run. Whether it works or not, who knows? I think it's hard to get anything through Congress these days. But it's also directly contrary to what what Congress did in passing the Federal Grants and Cooperative Agreements Act. And that is to try to create some real some principles around how these instruments should be used. So if HUD succeeds in that legislation, they will get consistency. It'll all be done through cooperative agreements outside the protest process. What they won't be doing is being subject to bid protest review about whether they're doing it right or wrong. If they're able to convince Congress to let them do that, good for them. I personally am dubious of that. But that is another way to approach this issue. And so it's interesting to see, I mean, millions and millions and millions of dollars are being spent by lobbyists in that area to try to get the law changed. And so far, Congress has not bit at all. But it's an agency way to avoid the Federal Grants and Cooperative Agreements Act, and we'll see if it works. So with that, it sort of concludes what we wanted to present. Thank you very much for participating, and we hope this has been valuable.